ADR-LINK is a program of the London Family Court Clinic and matches families referred for service to qualified ADR practitioners. The practitioners are not LFCC employees and do not work for Children's Aid Society offices. They are independent, impartial professionals trained to assist families and CAS to work towards resolutions that will focus on the best interests of the child or children.
As we forge forward and continue working with Indigenous nations, we want to first acknowledge, respect, and recognize the deep connection and historical relationship Indigenous peoples and the land we share. With support, accountability, and much respect to the following traditional homelands and territories of the Anishinaabe, Ojibwe or Chippewa Nation, Haudenosaunee, people of the Iroquois, which includes the United Nations, Lenape, also known as the Delaware, and the Attawandaron, also known as the Neutral, the Wyandot, also known as the Huron. There are 11 First Nation communities in the region of southwestern Ontario and over 120 First Nations in all of Ontario.
Alternative Dispute Resolution, most often referred to by its acronym of ADR, came into being in 2006 when the Child and Family Services Act, as it was then called, was amended to stipulate that Children's Aid Societies must consider ADR for children who are or who may be in need of protection. There are three main prescribed methods of ADR: child protection mediation, family group conferencing, and original dispute resolution, which is sometimes called Indigenous approaches to ADR. There is a Ministry Directive, CW-005-06, which outlines the three prescribed methods of ADR, as well as a fourth option that can be community-specific and is approved by the Executive Director of a Children's Aid Society. The directive outlines the qualifications and criteria for ADR facilitators, including criteria for neutrality, use of a written agreement including confidentiality provisions, and the conditions under which the CAS must provide notice to the Office of the Children's Lawyer. Referring workers from Children's Aid Societies, band representatives, FNMI communities, or any other party can request ADR services for families, either prior to court involvement or during court involvement. A judge may also request that the involved parties consider participating in a prescribed method of ADR. All ADR services in Ontario are completely voluntary, and participants can elect to not participate in an ADR service. In the West region, ADR-LINK is funded by the Ministry of Children, Community and Social Services, also known as the MCCSS, and housed at the London Family Court Clinic. ADR-LINK has the responsibility to manage referrals and match the referral to an ADR practitioner. For more information on how to make a referral, please view the video on ADR admin and how to make a referral. Let's look at an overview of the fourth option of ADR, also known as the other option. In terms of the fourth option, the directive states, where the above methods are not available or where another method is deemed more suitable, a Children's Aid Society may wish to use another method of ADR. A society may use another method of ADR, but that method of ADR must be described in a detailed written proposal, satisfy the criteria of a prescribed method of ADR as outlined in the regulation, be facilitated by a person who meets the criteria outlined in the qualifications and experience section of this directive, be assessed and approved by the Executive Director of the Children's Aid Society involved. If you are considering making a referral for the fourth option, you may want to consider having a consultation first. Either contact ADR-LINK directly to set this up prior to providing referral information, or complete the referral form and tick off fourth option, and ADR-LINK will set up the consult with an ADR practitioner experienced in creating the fourth option process. Here's what you can expect. The ADR practitioners will meet with the referring worker and manager to review the details of the referral to see if it qualifies for the fourth option. At a very basic level, the other prescribed methods of ADR must be considered to see if one of these will be sufficient to meet the needs of the family. If they do not, the fourth option will be considered. Here are a few examples of when the fourth option has been applied to different situations. A young child who was seriously injured in an accident while in the care of a parent needed specialized medical treatment that could only be accessed in a community many hours' drive away. The ADR practitioner designed a process so that all stakeholders could partake in planning with the goal of returning the child to her community. Separate planning meetings were held with education stakeholders, social service stakeholders, medical care practitioners, and hospital staff and family members to create a comprehensive plan. The child was eventually able to return to her community, and all stakeholders contributed to a successful plan which the courts ultimately endorsed. Another example involves a mother who had an intellectual disability and some mental health challenges. She self-declared that she could only last 1 hour in a meeting, and then she got agitated and started yelling at people. The mother had children in foster care, and between herself and her grandmother, wanted to put a plan forward which would have the children placed in the mother and grandmother's care. The ADR practitioner provided a family group conference experience over many meetings, each lasting an hour. After 4 to 5 meetings, a plan was created which addressed the worries and concerns of the Children's Aid Society, and then ultimately endorsed by the courts. The children were returned to the care of the family. The last example is how the fourth option funding is used most often. Parents had separated many years prior, and yet the conflict continued. There were 5 children caught in the middle of this conflict, which caused the older children great anxiety and psychosomatic issues, like stomach aches, headaches, and bowel problems. The ADR practitioner designed a process whereby the parents received individual counseling by a clinician trained in the New Ways for Families coaching prior to the child protection mediation. New Ways for Families is a specific coaching program aimed at improving co-parenting relationships for parents embroiled in a high-conflict custody and access matter. Once the parents had completed the sessions with the New Ways for Families coach, they addressed their parenting plan with the assistance of a child protection mediator, also trained in New Ways for Families. The parents were successful in creating a parenting plan that addressed both decision-making and the children's schedule. The Children's Aid Society was able to close their file. There are many ways to use the fourth option for families. It takes creativity and a commitment to customizing proven ADR and counseling processes to meet the specific needs of a family. Here's what you should know. All parties involved in a case will be asked to consent to undertake this ADR under advisement of their legal counsel. All participants will be made aware prior to the commencement of this ADR that this is a voluntary process, and they may terminate their participation at any time. The ADR practitioner will meet with the parties to explain this ADR process in detail and to respond to any questions or concerns proposed. A confidentiality agreement will be used that satisfies Section 2 of the Ministry Policy Directive CW 006-05 with respect to confidentiality and access to records and information. The ADR practitioner will write a draft fourth option proposal and send this along with supporting documents to the referring worker. The worker will have their executive director review and, if approved, execute their signature. This package is then reviewed by ADR-LINK for funding. There are a few more steps needed to access fourth option funding, but these checks and balances are in place to ensure that the funding is used appropriately for these harder-to-serve situations. For further information about the fourth option of ADR, please consult the ADR-LINK website www.adr-link.ca.